Stanford University.
This presentation is delivered by the Stanford Center for Professional Development.
Have a first to invent. We'll go through a little bit about first to invent today. It's a fairly complicated question, a legal question of trying to put together the right evidence and be able to get it in front of the patent office. And what are we moving towards? First to file, which kind? C. We're going to keep our grace period. This is part of American patent law, and this is not something that we're going to change. And so we're going to continue to have a grace period despite the fact that we're moving to first to file. The rest of the world, what system do they have? B. They have a first to file system, but they do not have a grace period. We'll talk about first to file. We'll talk about statutory bars. I don't know if we're actually going to continue to call them statutory bars under the next system. A little bit about foreign filing, and at the end, we'll talk about how to prepare a provisional patent application, which of course is the next assignment. Before we get too far into this, though, I want to get a little bit of feedback on how the assignment last night went. Did anyone complete it in far less time than they expected? How long did it typically take? $10 hours? 15 hours?
12.
20 hours. Yeah. That's kind of what I was expecting. Did anyone have fun doing the patent search? It is kind of fun. Like, you can kind of get trapped in this thing and just be like, oh, it's really interesting. Look at all these inventions. The time that you spent searching, how much of that was actually productive towards the towards the assignment? Yeah, as I mentioned before, like, there's a lot of information there, and we as engineers and scientists are going to take a look at this and say, wow, this is really interesting. Look at all these things. And look at all these things that have failed. Here are all these great inventions, and yet we don't see any of them on the market today. I find it as almost like an interesting little graveyard of technologies that we just simply don't see. What else on the feedback on the actual writing part? How well did that go?
Some examples really helpful.
Yeah. Great. I'll continue to do that, and I think that's without some kind of guidance like that, I think it would be a near impossible task. Yeah.
I had a hard time judging, how much of the report to spend on reviewing the prior art versus kind of going stepwise through the 5 requirements of patentability.
Great question. Maybe there's some kind of breakdown in the future of, hey, spend a third of the time doing the outline and the search, and a third of the time kind of reviewing what you have and starting to prepare some of the outline for the analysis, and another third. My hunch is that last portion gets kind of squished. And that's the only portion that I actually see. Right? I don't see really like how much time you spent searching. I could look through those, but with 67 students in the class, I'm not going to repeat the search. I'm not going to do the search for you and compare my results versus your results. I'm good enough at looking at a bunch of results and thinking about, is this a good search? What would I have expected to see? Especially fields outside of my technology, though, I'm not going to be able to do that. And so, unfortunately, I'm only going to be able to see that last portion. But this is actually fairly close to real life, because your clients, if you were to move on into patent prosecution as a career, then your clients don't actually see that other part either. All they see is the analysis.
Well, my question is more to do with the actual final report we produced, because there's definitely a section that summarized your search, summarized prior art, and then the very end, just covered those. Is it usable? Is it novel? Is it this? So the question is, those answers I can either put one line in, saying yes or no, or do I go on, according to statute, blah, 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 per case study, blah, 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 this falls into these requirements.
I think that answering utility, people spend about 3,000 times more time than they need to. I think a sentence probably would have been fine. And answering obviousness, people don't spend nearly as much time as they should. And so I think that typically people treat those as all kind of equal questions, and in reality, patent law comes down to whether or not something is obvious. Anything else on that assignment before we move on? Quick procedural thing about the next assignment. So typically you would take that same exact topic and now write a provisional application on it. If this wasn't patentable, if that was what you decided, that this wasn't patentable, then we're going to bend reality a little bit. Hey, we're going to forget about this or ignore this one piece of prior art. Or we're going to ignore everything that was filed after 1989, or something along those lines so that we could get something interesting for the provisional application. In very rare situations, I'll allow a student to actually change the topic. Hey, this just doesn't make sense for me to spend any more time on this topic based on what I found. And so if that's the case, you need to ask for approval to switch topics. Otherwise, I will assume that you're going to use that same exact topic for assignment 2. This actually goes for assignment 3, the optional one, as well. And so I'll assume that you're going to use the same exact topic for that one. In some situations, I'll allow someone to switch. Throw a softball out there. Tom Gwynn. Tom, what's the difference between first to file and first to invent?
In a first to invent system, an inventor whose work is invalidated by prior art can go back and show that if he invented the patentable invention before that prior art, then he has a claim against rejection. So it's not only who files first, but actually who invents first that matters. Whereas in a first to file system, he'd be out of luck because that other person filed before him.
Awesome. We're talking now our existing system, and this is pre-March 16th, 2013. We are in our first to invent system. When two independent inventors have invented the same invention, what are some of the factors that go into determining who the first true inventor is? This is going to go to Raven Jackson Stone. Raven.
Hi, so I think it's looking at records, or basically kind of spiral notebooks of what your inventing process has been and looking at the dating of that.
Yeah, and so great. So there's some kind of evidence of that you have this. What else goes into it? Okay, can someone help Raven out? Yes.
So it's the conception date.
Which kind of goes back to the bound notebook.
Yep. Then like the reduction to practice date, like when it was actually put in practice, and then the regional diligence date. So like it's kind of a complex process, but it's basically you have to have the records for all 3 of those things to be able to prove that you invented first and it was used first.
Great. What's your name again?
Corey Monkey.
When you're determining the priority in a first to invent system, the reasonable diligence of one who is first to conceive but last to reduce to practice from a time prior to the conception by the other. This whole phrase, even though I've seen it now 1,000 times, is still relatively confusing. We're not going to spend a ton of time on this. I used to spend effectively the entire lecture on this topic, but because we're moving away from it, I'm not going to spend a lot of time today. I'm going to introduce this concept. This will still be in effect for all the patent applications filed before March 16th. And so this is still going to affect an enormous number of the U.S. patents. That's not going to change. The 8 million patents that are out there, the millions that are still, probably not millions, hundreds of thousands that are pending right now, and a ton that are going to be filed on March 15th. Those are all going to be under the under our first to invent system. And so this doesn't affect those. When we move to a first to file system, it's only going to affect those filed after. And so we still need to know this and understand how this works. And you see as kind of the conception date. And this X is going to be for our reasonable diligence. So this was second to file. So in this first example, this the number one inventor was second to file, but first to conceive. The important part here to note is that that particular inventor was working diligently all the way up to this reduction of practice, and that before this other person kind of conceived this and moved to the reduction of practice, that this first inventor was working diligently. What breaks down here, in that you don't actually get this earlier date, in the first inventor, so in our first invent system, this particular inventor is going to win. What breaks down is that when the first inventor wasn't working on it diligently, and the public policy works a little bit like this. I came up with a great invention. I wrote about it in my notebook. I put it on my shelf in my basement. And then years later, someone else tries to patent something, and I go to my basement, and I pull that out, and I say, look, I invented this 10 years ago. This was actually mine. I should be the inventor of this. We don't want that. We don't want someone to have just shelved that particular idea. And so we're not going to give them credit unless they were diligently working on that particular project. This is reasonable diligence. This is not due diligence. Those phrases sound very similar, but those have nothing to do with each other. So this is whether or not they were diligently working on it. There's case law out there of taking a summer off is not diligently working on it. There's case law that tries to say that a couple-week vacation is not diligently working on it. When I've proven this in the past to the patent office, and we've used First to Invent to our advantage of our clients, we try to come up with something on every single week. Here's an email from this particular person, from the CEO to this particular supplier. Or here's an email from this supplier and how we're going to react to that internally. Or this is a sketch that was done on this week. Or here are some notes that were taken on this other week. And coming up with a piece of evidence on almost every single week will allow us to be able to go back in time. And so if this diligence were to break, and there's no diligence right here after someone else had conceived it, then inventor number 2 is the true inventor here in a first to invent system. And so you can only go back in time as long as you were diligently working. As long as you were diligently working, you're allowed to kind of go back in time to the point where you conceived it. And that's when your first to invent date is going to be.
What if number 1 was done the whole time, but he was in Europe?
So good questions in terms of like whether or not that's going to work in terms of the United States filing. Believe that works here under U.S. law.
The inventor then would be number 2?
No. Under U.S. law, I'm about 80% confident that's going to work.
Okay, because there's in this country in the first sentence. So I was just wondering if that meant if the inventor is somewhere else, then he's not considered the inventor.
I have not seen case law on that. And so from what I've seen, as long as it's kind of a member of the World Trade Organization, that's still going to be considered evidence. I haven't seen that particular case. You would think that these things come up all the time, that people file patent applications very similar to each other. But what this type of interference comes up when someone is inventing and going after the same exact subject matter, not similar, like the exact subject matter. And so we talked about this in the claim language of getting that abstraction level. So even if this was the same exact product that someone had come up with, the claim language might be different in terms of what they're going after. I'm going to make a note to figure out the answer to the question. That hasn't come up in my career about European evidence. What's a conception? The conception is the formation in the mind of the inventor of a definitive and permanent idea of the complete and operative invention. What does that mean? So it's complete and operative only when the idea is so closely defined in the inventor's mind that only ordinary skill would be necessary to reduce the invention to practice without extensive research or experimentation. We're trying to put some kind of words on something that is incredibly fuzzy. When is the conception date? So you may have had this idea of, all right, well, I know I want to make this travel mug, and the idea is to make it so that it's got a wide or a large flow rate, but it doesn't leak. That's not a conception. We don't know how to make this thing yet. That's just a blue sky, like, hey, this is a great idea of a product. There's a market here, but we don't know actually what the invention is yet. But being able to say, I know how to sketch this, even if it's a rough sketch, and it turns out to work, then that's going to be the conception date. We need to have some kind of evidence, and that's why inventors have bound notebooks. Bound notebooks are great because you can't put pieces of paper in different orders. And so if you're always writing in a bound notebook from beginning to end, and you're putting X's on things that you skip over, then that's a pretty decent, and that's your practice, and you could show that that's your practice. You have 12 years of bound notebooks of all of your ideas, and this is, you always put them in order and you're not jumping around, then this is great to be able to show that as evidence that on this particular date, this is what you had, this idea. And when we've done this before, submitting to the patent office, one of our clients didn't have a particular date on the page that we really needed. But there was a date on the page before it, and there was a date on a couple pages after it. And so we could kind of bound that date. It was after this date, and it was before this date. We don't know exactly when it is, but we know it was between these two dates. Because this is a bound notebook, and the practice was to write from beginning to end on every single page, and not skip around.
16, all bound notebooks will be obsolete. I mean, new bound notebooks will be obsolete, that people won't have to do that.
New ones, yes. And so we're not going to have to do that. There's still some, we'll talk about derivation. We don't really know exactly how the derivation aspect of the law is truly going to work. And so there may be some reasons to keep lab notebooks around, but I've been effectively telling people there's no reason to implement a lab notebook policy right now because this thing's going to change in a few months.
We're moving to a digital world. I rarely ever use paper, much less a single notebook anymore that's bound. Do digital timestamps count for anything? I figure they can be faked pretty easily.
Yeah, they could be faked pretty easily. In terms of the little date on the printout of your email, because that's what you are going to be submitting is a PDF of the printout of the email. And so that particular document, that date on it, can be faked pretty easily. And so there was a couple years ago where I was actually looking into creating a little side company that would help digitally stamp and encrypt particular documents. And they would have a hash of that particular document. You could always go back and prove that that particular document happened on this particular day. We're starting to move slightly away from the need for that. Digital signatures are starting to be accepted. The date on the email, while that's not definitive, it's actually, when you submit evidence, strangely, you black out the date. And you black out the date because you don't need or really want to give the exact date on that piece of paper. And so what you're doing is saying, there's a date underneath this, underneath this piece of paper. And this is what it is, March 13th. But when you submit it to the patent office, you submit this particular piece of evidence, and maybe this is your sippy cup. And you submit it with the date blocked out. And you say, this date is before this other date, the critical date. And so we don't actually have to say what that date is, but we are testifying under federal oath that that date occurs before some other date.
Why don't we want to say what that date is? Because they could find other stuff that
Right, we don't need to give up what that date is. That's a pretty critical date. That is our conception date, and we don't want to have another competitor come in and be able to understand exactly the date that they need to beat. It'd be great to be able to say, we beat the other critical date, but they don't know by how much. And so they won't know whether or not they could actually beat our date. So it's kind of a weird practice, but that's actually... So when you go back to asking the question about email and digital stamps, I think that that's somewhat skirted by the concept of you're going to black out the date anyways. And you're going to, under federal oath, say this date happened, this email happened before this other date. Does that answer your question?
Do they ever check?
What's that?
Do they ever come and check what the date is?
You're saying it under federal oath.
Yeah, usually everything that, they can check. When we tell something to the FDA, they come and check that what we said was correct.
Yes, but this is something where you're effectively, using the FDA analogy, you're saying that, look, this is proprietary. We're not going to give this up right now. We're going to block this out. Yeah.
So the problem with digital being able to be, the dates being able to be faked really easily, it seems to be that would be even more of a problem for something on paper, because let's say that inventor you were talking about who shelved his notebook didn't have dates on anything and then just went back and put dates on every page.
Right.
So is that part of the reason why we're moving to a different system?
No, it's actually not at all.
Okay.
I think that a lot of people get caught up in the concept of faking dates or lying. Again, this is federal oath. This isn't necessarily like something that you want to play around with unless you enjoy wearing like orange jumpsuits. This is. I know there's often a lot of money at stake, but this isn't something that you would typically be so inclined when you get down to it to be actual lie under oath. And I've had a lot of clients like initially say, well, couldn't we just say this date? We're off by a couple of days. I bet you I did invent it a couple of days earlier. Can't I just say that? Then I remind them of this, and they quickly back down. And so it's not necessarily that aspect. It was much more the aspect of this was meant, the first to invent system was meant to be able to give a smaller, less funded company the ability to be able to still get a patent in light of a larger company with many more resources being able to move faster. And so we thought that this was more fair, that the Constitution gave rights to an inventor. And the inventor in our minds is the one who invented it, not the one who filed it. And so we want to be able to protect that particular person, that entity. As long as they were continuing to work on it, we want, even if it took them a much longer time, as long as they were working on it hard, that's the person we want to celebrate. That's the person we want to reward. But it turns out that this thing is now a little mini litigation when you're trying to fight in an interference court of who actually was the first to invent. And a mini litigation maybe a few years ago was a couple $1,000s, and now it's starting to look more like $100,000, $150,000. And that's no longer giving the small company an advantage to be able to beat the Goliath. And so we've found that the system of trying to be fair to the small company just doesn't work. 99% of the time, Goliath wins in this interference. And yet we have all of this litigation around, and all of these question marks around who is actually the first to invent. Because it's not crystal clear. First to file is really simple. Were you there or not?
Have a disadvantage in the new system as well, though, because if they are slower.
So they do have to invent, or they have to file first. Yep. Or they publish, which is kind of an interesting little twist that we still haven't figured out yet. If they publish first, then they have a grace period in which to go back and file, and that publication is going to mess up someone else's filing after that.
Define excessive research or experimentation. Because if you're doing diligent work, right, on this, it involves research and experimentation mostly, right? So how do you balance those two?
Yeah, so that particular phrase here is that so someone else, it's a phrase to be able to say, look, you're almost there. We don't have to, it's not, a great case on this was Thomas Edison and the filament, and there was 1,000 different filaments that he was testing. Was that excessive or not, or was he almost there, like when he came up with the idea? And so, that's like some of the test around whether or not you were almost there in terms of like, hey, this is just routine work to be able to get to the invention, to reduce it to practice. That reduction to practice is kind of this, it's just a legal phrase. Was the process successfully performed? Was the machine assembled, adjusted, and used? Did we actually manufacture the invention? It's important because when people typically see this slide that they say that, oh, it's really, you have to make something in order to patent it. That's not the takeaway from this slide at all. That if you actually file a patent application, that's considered a reduction to practice. That you've taught someone how to make it, and teaching someone how to make it is good enough. I'm not going to spend too much more time on this because we are moving away from this area of the law, and there's only so much I could cover in one lecture. Diligence only matters kind of in this in the scenario where you are first to conceive of the invention and then second to actually file. Andrew Ladd? Andrew? Stephen Lin? Stephen, what's the grace period in the United States patent law?
It's basically what we were just talking about before, that as an inventor, you have a year of grace period to file either provisional or patent application for your invention. That 1 year is set by the prior public disclosure of your invention.
Awesome. Thanks, Steve. It's a great question. So it comes up often. And so can you stack these particular rights? Can you take a public disclosure, so on the timeline, if you publicly disclosed, can you file 12 months later a provisional patent application, and then 12 months later file a full patent application? What's the answer to this? Yeah, technically you can. What's the problem with this approach? What's that?
Someone can file a non-patent law in the meantime, and you would have.
Well, in the first event, you'd be fine.
I think you cut down the number of years that you can actually have monopoly over the invention.
So this actually works out in your favor because you're actually pushing that into the future. So yeah, you don't get an issued patent sooner, but you do get it. You just shift it when you're into the future.
Possible that the publication is then seen as prior art from the application perspective, even though provisional isn't?
In what case would that be true? I'm getting at it.
If you're following a world patent?
What's that?
A world patent? Or like international patent?
What's the weakness of this approach? How would you attack it?
Because you don't have claims in the provisional patent, so it's more narrow in terms of topic.
Possibly, but I mean, if you write your provisional well, then this is going to be fine, which I just gave away the whole thing right there. In this scenario right here, when you're stacking up the grace period for the first 12 months, and then your provisional to full application for the second 12 months, you're absolutely relying on that provisional patent application. And if that provisional patent application doesn't work, then you're 24 months out of your from your publication, and you're way outside of your grace period. So under this scenario, if I was being attacked, my client was being attacked for patent infringement, the first thing I would go after is trying to show that that provisional application was no good, that that provisional application didn't support the claims that were eventually filed under that full patent application. And if that thing wasn't great, if that provisional wasn't awesome, then that would be the weakest link for sure. And so I tell clients that want to do this that we could go ahead and do this. But that provisional application is going to cost the same amount as that full patent application because it needs to be that good. Because otherwise, that is the weakest link, and someone's going to attack the provisional as not supporting that full application. And under that case, we're not going to get that date. And if we don't get that date, we're outside of our grace period, and the whole thing falls apart. We get nothing. The whole patent just disappears. There's no patent infringement anymore because that provisional doesn't actually support that full application. And so under this case, if this provisional doesn't equal that application, then that's not going to work. Or there's at least going to be a weakness there. And if you're going to file a provisional that's that good, it doesn't actually make any sense. Just file it as a full application so you could get an issued patent sooner. Unless you were stuck in FDA world, which a lot of, this is what pharmaceuticals do. They don't typically use their grace period, but they would typically file a provisional application that's effectively a full application, and then wait 12 months and file the full application. Because that's a great way to add another year onto the life of that patent, which could mean millions and millions of dollars for a pharmaceutical at the end of that period.
When you file a provisional application, you can't edit them, right? So you have to file another one and combine them into your non-provisional application. What's the date for the grace period for that? Like, this is from the first provisional application?
It's going to be in whatever the delta was of that public disclosure. And so you may have different grace periods. You may have different filing dates or priority dates, depending on what that public disclosure was. And so typically, you have a software startup, there would be some disclosure on some date, and a little bit more disclosure on another date, and a little bit more as that company's rolling out new features. This is particularly relevant in kind of the lean startup world. And so you may want to try to file provisional applications before each of those subsequent launches or subsequent rollouts. You're going to want to file a full patent application. You can't go back more than 12 months back in time to be able to claim priority to a provisional. And so this can't be, if you filed a second provisional over here, you can't wait 12 months and still claim priority to this first one. Does that all make sense? Yeah.
So if your provisional patent isn't as good as the real patent and it doesn't cover everything said in the real patent, does the real patent have to be filed then 12 months after the published date?
Yes.
Okay.
And that's the very long, or that's the short answer. And the very long answer was the discussion of can you stack the grace period along with your provisional 12 months. Technically, you can. Practically, you don't, unless you absolutely have to. I mean, if that's the best you can do, then that's what you do. But you try to avoid that at all costs.
The actual patent subject matter from the provisional one to which it refers.
So the test is going to be whether the claims of the full patent application are supported by that document. And so those two documents could actually look very, very different. You could add some information, you could subtract some information, but the test is whether or not those claims are going to be supported. And when we write the provisional, we don't necessarily write claims, and though certainly, even if we did, those aren't necessarily the claims that would be in the full patent application. which might not be the same claims that you end up with after prosecution. And so we don't really know what's going to end up being important for disclosure. And this is kind of a little preview of what we'll talk about later today. Put more information in that provisional. You want to be able to support whatever claim you end up having in the future. And the best way to do that is to have more information in the provisional.
Does it happen that the patent office comes back saying, well, this is not supported by your provisional, but by itself, it's fine. So we discard the provisional and just issue the patent based on...
So that usually comes up when you need the provisional. And so, a piece of prior art comes into play, the patent office is trying to reject you, you say, oh, well, we have the provisional date, and look, it's supported. Or the patent office can't find anything before the provisional, they find it after the provisional, and now they have an incentive to try to attack the provisional and say that your provisional doesn't support this particular claim.
How good the
It
provisional is.
usually doesn't come into play at all. I mean, 90% of the time, like how good the provisional is doesn't come into play. It comes into play in these edge cases of whether or not you need that particular date. As more and more patent applications are filed, then this is going to become more and more important. And as we move to a first-to-file system, I suspect this will become more and more important. I didn't realize this back then when I started teaching this class, but filing your own provisional application is going to be really important. You're going to want a first-to-file date. You're going to want that earlier date. And I've mentioned this briefly, but the larger the company, the longer it will take for them to actually file, not faster. Unless that this is something where they have reoriented their entire company around filing patent applications quickly. This is not something that's their core business. But as a small startup, you could have the same person be the CEO, CTO, and CFO. And so they know the technology, they know the vision, and they know they have the money to do it. So just go ahead and do it. Or it could just be 3 people, and those are the 3 people there. And so like getting to this decision is really quick. And again, you could have an idea in the morning, write it up in the afternoon, file it that night, and get that day's filing date. I don't think our large companies could compete with that. I really don't. And so when people talk about this as being as a disadvantage to startups, I think that this is awesome. Works really, really well for small, nimble companies, especially if they know how to write their own. So what we're going to do today. John Voorhees.
Yeah, I have no idea.
Okay. Gotta take a volunteer.
There's a case about they want to double extrude soy-based product to feed it to animals to lower cholesterol, and they had publicly disclosed it. And it's in like 16 or so printed PowerPoint slides at 2 conferences, and it was rejected on the basis that publicly disclosed before the grace when the grace period was up. They tried to get that patent.
Tell me a little bit more about the invention.
Let's see. Single extrusion is well known to help lower cholesterol and some other benefit in soy products. So they decided, let's do double extrusion. Actually, it helps it even more. So that was their addition to the...
So it's a pretty simple concept to understand. Everyone already knew how to do it once. We're just saying, do it twice. Got it. What's your name again? Thanks. Double extruding soy, reduce cholesterol, presentation, printed slide presentation at a public conference. It was 14 slides, not 16. The printed slide presentation was displayed to a wide variety of viewers continuously for 2.5 days. There was no stated expectation that the information would not be copied. This turns out to be a somewhat important factor. The presentation was not indexed or otherwise made available afterwards. So it was only there that people would actually be able to access this information.
Question about this. So let's say you're going to a conference where the rules are that there's no you don't take photos and you don't disclose anything, then on top of that, do the presenters need to say, like, oh, this is, private, please don't share anything?
So
Is it their
it
responsibility?
depends. It really comes down to some of the factors that we're going to talk about this case, but whether or not this is the law. So we could argue back and forth. Someone might have come in that didn't actually get that email or understand that particular rules of that conference. Or maybe the rules of the conference were only supplied to 80 or 90%, not all of them. Is that good enough? Is that something where the expectation was that everyone there wasn't going to be able to take this information? And so it's a big factor is this expectation of whether or not the audience expected this information to be confidential or to treat it as confidential. But there's a whole bunch of other factors. If there was 1 million people there at that conference, that's going to be a factor that says that was a public disclosure. If there was 15, maybe that's a small factor to say that it wasn't. But there isn't any heuristic that we could put on this to be able to get to a right answer. And this is a great example of area of the law.
About those 14 slides because they looked through the computers of everybody at the company and figured out that people went to that conference and had those slides. Like the presentation wasn't indexed. So how did they access the fact that the company
through discovery? Hey, what did you actually disclose during that presentation? And you're going to have to give up that information. Did you, through discovery, did you give a presentation on any of this information? Yes, I did, on this date. On that date, did you present this topic? Yes, I did. Can we get those slides?
So you don't have to give information until you're asked questions, and then you have to read it.
We'll take a volunteer for this one as well.
They upheld the previous case. They didn't let the patent go through because they said it was publicly disclosed, even though it wasn't indexed or anything. Because it was made very simple for the public to understand. It was presented in slides for multiple days. So it was made adequately available to the public, the court determined. And indexing is not the only thing that considered public disclosure. Yeah.
Awesome. What's your name?
G and Storage.
Thanks. Length of time that the display was exhibited, the expertise of the target audience, the existence of reasonable expectation that the material displayed would not be copied, the simplicity or ease with which the material displayed could have been copied. These are all significant factors in this particular case. I'd say that there's probably at least a dozen that kind of go general factors for these types of cases. Again, I think this is just a good example of just the area of the law that there's a bunch of factors and that someone, a judge or jury, is going to be weighing these factors to come up with a decision, and that there's arguments on both sides of what factors should be used and what factors, how they should be come down on which side, and then how much each of those factors should be weighed. In the City of Elizabeth case, the Supreme Court held that the experimental use of an invention, despite being used by the public, is not a public use. In the Egbert case, the Supreme Court held that the experimental use of invention, despite being private, is a public use. What was the rationale behind these seemingly contradictory results?
So in the Elizabeth case, the inventor was using the pavement pictures as an experiment to try to further develop it, whereas in the second case, the inventor had his girlfriend wearing the corset, where it was more like a commercial use, even though it was private and individual. So it was the difference in the
So there's a
commerciality.
bridge that hundreds of people cross every single day for years, and that's not public disclosure. And then a corset by a girlfriend, probably worn at night, is a public disclosure.
Used by this, it was like the surveillance of the inventor to develop the product in the first case. So it was like experimental. I don't know. It seems weird, but
So tell me more about the inventor's mindset then in both of these.
okay. So in the first one, the inventor is trying to use this to enable him to test something out. So to test out.
Was there another way of testing it?
I guess he could do it privately, but it seems to be that the issue of the priority date is not about privateness or not. His thing wasn't commercial though. Like he wasn't having people pay for it. It wasn't for commercial use, but the second one was intended for commercial eventually.
What commercial benefit was gained on the second one?
I don't know. It doesn't make a whole lot of sense, but that's what it said.
The second one, there wasn't an explicit understanding that the girlfriend wouldn't release it, or he didn't say, oh, this is private.
Girlfriend, course. What was?
It's not explicitly understood or written down. The girlfriend decided non-disclosure of that.
Was there any such thing with the bridge?
Experimental.
There was no non-disclosure agreement that every single person signed going over the bridge, was there?
I think earlier we talked about whether it was for experimental use under supervision of the inventor. That wasn't.
Why couldn't the corset have been experimental use? Was that comfortable? How did that work? That seems pretty easy to fall under experimental use.
It all comes down to reasonable diligence because the inventor of this sidewalk was checking it every day for the 60 or whatever years. So you could say he was diligent and he was taking notes or whatever to improve it eventually before the reduction of practice. But then for the second one, before he didn't show diligence because he just was working hard for years and he didn't really improve it or anything. The court said that this is beyond
At some point.
The other thing is, you asked earlier, is it necessary for the inventor of the bridge to have it tested by the public? And she said no, but I disagree. I think the difference is that the corset could have been tested in private easily, whereas the bridge, to know that the bridge is suitable for people walking over it, you need people to walk over it. And you can't go, hire a group of 200 people to come privately walk on your bridge every day. So, I guess you could, but,
Or one person just repeatedly walk over it over and over again.
Die before adequately testing the bridge. Or, you have to be a really fat person.
I think you're right.
The text is if it's used by even one person other than the inventor, which in this case was the girlfriend. The girlfriend wore it. The inventor didn't wear it. So I guess would this would have considered not in public use if he had just tried to enforce it himself? Then question, because I do medical device design and I think of so if the inventor can only try the device out himself, where do we go with medical devices? Colonoscopy tools or something that works.
We get into some interesting questions like that. I don't think this is really about trying it yourself. I think this is more about the concept of how much there was actually testing, the feedback, that he was out there every day poking it with his cane or stick and being able to see, and we're talking about the first person. The first the cane, whether or not that was going to whether or not that was actually working. And the second inventor didn't have any feedback mechanism. What was probably one of the other complications to this case? What was the relationship with the inventor in the second case?
It was a girlfriend, and my guess is that relationship may have ended, and she moved on and perhaps wore the corset in other settings.
Or potentially a mistress, and being able to put that particular person on the stand and be able to say, this was the relationship and this was my instructions or something along those lines may have been particularly difficult to get to that. And so my guess is that was actually part of this case as well. I like these set of cases because not only are they entertaining, but they do specifically point out kind of the importance of testing and feedback. This comes into play exactly like this in software. We released a beta. Okay, well, what did you do with that? How many people were there? What kind of feedback did you get? Were you asking them for feedback all the time, or did you just let them play with it and then hope that they were going to upgrade later on? If you weren't actually asking for feedback, is that an experimental use or not? What would you say here? What would you advise your client if they wanted to, if they had 13 months ago, they had released a beta to 50 people?
If they sell it as a beta?
So yeah, if it was for sale, that's a whole nother problem here. Yeah, and there's no way that there's no experimental use on sale. So it was a free beta 13 months ago. Can we file it? What questions would you ask?
The first question is, you asked, did you ask the users for any feedback? Did you take feedback from them directly? But then a second set of questions would be, did you derive feedback from their use? Like, if you're using software, a lot of times in the course of use, you can be running things in the background that are monitoring what the users are doing. And even without their necessarily them giving feedback explicitly, you can get implicit feedback from them from how they use the software and things like this. Did you take any recorded data from this? Any notes, anything like that? So, there are a lot of things that can be experimental, even if you're not directly getting feedback from them.
No, those are awesome points. What's your name again? Thanks, so. And so the concept of getting that. So, the first inventor, he wasn't necessarily asking people, how do you like my bridge? But he was testing the bridge. And so in a very similar way, we don't have to ask all of those 50 beta users, did you like my software? What kind of feedback? But actually seeing how well it worked. How well did it scale? How well did it handle, what were the speed? What was the performance? Things like that. And to be able to monitor that, that's great. These are great questions to ask that particular client, whether or not those things happened, and to what extent did they happen. And if they happened at a great deal, then that could potentially be called an experimental use. I think it's very difficult in the software world to call something experimental use. And so I would be very careful. I'd much prefer to file that before the grace period runs out instead of after, hoping that that was an experimental use. But this is something that when you're at the 13th month, you often don't have that option of filing ahead of time. Yeah.
So adding on to proving that you are either actively or impulsively taking feedback data, you also have to prove that you are also acting on it, because if you're just running some kind of system that's taking data implicitly, but you don't show that you made any improvements to it, and you did that for 13 months, would that qualify as exceeding the period?
Yeah, that's a great question, but I don't actually think that improvements are part of the experimental use. You don't have to be necessarily working or making improvements, but rather seeing whether or not the improvements needed to be made.
If you're taking feedback, assuming the beta is perfect, you don't make any improvements to it, and then wouldn't there be a question of, so why did you take a long time to file a patent?
Yeah, these are great arguments, and why, from a public policy standpoint, do we want someone to wait that long? We don't. We want that to be pretty clear for the rest of the society that if something was in public use 13 months ago and a patent application was filed, that other people could go ahead and make this. And we talked about all of these aspects. First to file versus first to invent, advantages and disadvantages. The first to file system, it's relatively crystal clear. Did this date beat this other person's date? What we don't actually have yet, or I haven't seen it, are whether or not timestamps are going to matter. And so, if I filed something at 12 noon and you filed it at 1 p.m., is that actually going to make a difference? From what I understand, that's not. We're just going to take these as whole days. But as we move more and more patent applications being filed electronically, we now know the exact date or the exact time. I think this would be unfair to those who are mailing, and how would they actually treat that? and an act of one government agency scratching the back of another. If you use express mail and you actually get, you mail something today with express mail label, so this is U.S. Postal Service, then you actually get today's date. When I moved out here 9 years ago, one of the factors of where we were going to live, because I was, we had the law firm was actually in our apartment at that time. One of the factors was how close was the post office, and was that post office open late? Because a good portion of my career, you would rely on the fact that the post office, there was a post office, a 24-hour post office that was close enough to you. Because if you didn't make the cutoff of 4 o'clock or 5 o'clock or 6 o'clock for express mail, and you needed to file it today, you needed that option of being able to go somewhere. In Detroit, in Ann Arbor, where before, we would go down to the Detroit airport. And very similarly, here in San Francisco, there's a 24-hour post office that will take and date stamp something at 11:59 as today's date. And if you want to, previously, if you wanted to get a job with a patent firm, a good way would just be to go close to midnight and go hang out at the post office. Because pretty much everyone there are patent attorneys or patent attorney assistants that are frantically trying to file something. And it'd be very crystal clear like why everyone was there that day. We don't have that, although there is actually some time where it could still play a part, because when you electronically file, we're actually on Eastern time. And so there is this odd chance of I can't make the 9 p.m. cutoff, but I could make the 12 midnight cutoff. That would actually be very difficult at this point because I haven't filed hard copy in a really long time. I wouldn't even actually know where to begin. But that was something that was incredibly important at some point. It wasn't FedEx. If you use FedEx, you get it when it's received. But if you use the express mail, you get it when you mailed it. First to file, easy to determine who was first. The disadvantage is that you're going to have rushed ideas. The rest of the world doesn't necessarily have, there are a lot of patent systems that don't have a provisional application. So a lot of them end up using the United States provisional. They'll recognize the United States provisional as an earlier filing date and as a priority document. I think this is the best way for us to be able to kind of slice this problem and kind of negate this disadvantage of rushed ideas. So having a rushed idea as a provisional application, but not spending all of that money on a rushed idea, then to wait in that 12-month period, be able to make that into a full product or at least test it as a prototype, and then filing a full patent application within 12 months. This particular graph is what our little chart I draw all the time with our clients when they ask, well, when should we file? And this first little part of the curve is the aha moment. And then the I built it, I learned a lot from it moment. And I know how to make it for the masses moment. And this is just kind of a very, very, very rough technology development curve. Ideally, we file a full patent application right there. Because this concept of getting all of these extra details turns out to be really important for the full patent application. You want to have those limitations. You want to have that experience. You want to have that insight that you gained when you actually built it and tested it. You solve a lot more problems when you do that. And from an ideal standpoint, you want to have filed as early as possible, and preferably 12 months before this date. And so I typically say if you know that you're going to build something and test it within the next 12 months, then let's go ahead and file a provisional. And if that's not going to happen within the next 12 months, let's wait until a future date where this will actually happen. And so this, to me, is kind of the way to kind of hedge your bets of getting in early on a half-baked idea and then making sure that that full patent application is going to have some fully formed concepts. Yeah?
So Those would be a strategy to just generate more revenue. Because if you get more people trying to push ideas through the door and filing, maybe USPTO makes more money.
So they don't make a ton of money on provisionals. It's only $125 on that provisional. And so they're effectively just taking that document and just accepting it and putting a date stamp on it and putting it in a file somewhere. And so my guess is, compared to the full patent application and maintenance fees, that this isn't, the provisional applications aren't a good revenue source for them. I think it's a great way to be able to solve this issue of the advantages of a first to file and advantages of a first to invent. Yeah.
So if someone has a product they publish in the United States and they patent it here but not in other countries where they don't have a grace period, are they not allowed to then patent it?
We'll get to that exact question in a few minutes.
Okay.
Do you have a question?
So in the text, I think you say that it's beneficial for kind of technologies that are rapidly changing to file provisional because you don't need to put claims in so that you can kind of change it however for your actual application. But does it ever happen that it changes so much that your provisional doesn't end up supporting your actual claims anymore?
Sure. So, technology companies, especially early stage startups, they evolve, they pivot all the time. And so if they're moving in a place where the technology is just very different than it was 9 months ago when we filed that provisional application, it's quite possible that that provisional application is now useless. Yes. Well, you don't lose it. You're just not using it. You could still go ahead and file a patent application, but it would be on something that you're not doing. Now, if you had a ton of money and you're fully funded and you just raised $25 million from Andreessen Horowitz, maybe that idea was still worth filing a patent application on. But my guess is that you're much earlier stage than that, and the funding is still tight, and spending money on a patent application that covers an idea that you've pivoted away from doesn't really make a lot of sense.
At a disadvantage if a competitor files a provisional, say 5 months later, that's a little bit closer to what you guys are working on, then you would kind of be out of luck.
The problem that I think you're trying to identify is the reliance on a provisional date. And so that's the biggest problem that I see with provisionals is not necessarily the concept of provisionals, but the reliance on it. That you guys might say after assignment 2 that, hey, I can now file a provisional. It may turn out that you actually wrote a really poor provisional. And so you may not actually end up getting that date for your full patent application that you file next year. But if you think that you have that date, then someone else might end up beating you to this. And so that's why I like putting in inventors' minds this concept of updating it. And you can't really update. It's the only thing that you can do is refile or file again. And so to make sure that you don't just think of this thing as it doesn't evolve with your company. If your company evolves, then you need to file another provisional on that. And again, this is where I think making and creating and filing your own provisional applications makes a lot of sense, because this could get pretty expensive. Yeah.
So you're saying that individuals who have no expertise in legal matters should just file their own provisional because as long as they file their patent within 12 months of the public use date?
That's what I'm teaching, is that you should file your own, or that you can. It may make some sense not to do that. It takes some time, as you'll find out, to write your own provisional application. And it's possible that writing your own provisional application takes more time than money, because time and money are actually both limited in startup world. It's not just money, it's actually time. And so it may make more sense to pay someone else to do it so that you could actually do things that are moving your company forward.
As long as the patent quality is really good, so if you didn't spend a lot of
No,
time...
sorry. So that provisional application needs to support that full application. And if it doesn't, then it's no good. No, so I think the point that I was trying to make was actually quite the opposite of if the particular provisional application was poor and you rely upon that as your date, it may end up losing to someone else that is able to file first after you, But because you didn't get your date, they actually beat you to the patent office. And so filing a good provisional application is really important. And so the concept of, can I teach you to file your own solid provisional application is my test, my challenge. In my experience, this has actually worked out just fine. There's plenty of provisional applications that you guys will write that I'd be happy to put my name on, like just solid stuff. You put in the time, it's actually not that hard. There are plenty of tricks, but as long as you understand the tricks, you'll be able to do this. We're running out of time a little bit, so I'll just go ahead. We're moving to a first to file. We've talked about this effectively the whole time. One important key fact here, though, that the rest of the world doesn't have a grace period. And so one of the solutions to the rest of the world doesn't have a grace period is to make sure that you file a provisional application before you publicly disclose. Because otherwise, you would be potentially losing out on your foreign rights. Early stage startups often don't really care too much about their foreign rights. Whereas their investors might be looking at this as, well, the United States is a great market, but the market we really want is China. And so losing those particular rights or forfeiting them right in the very beginning of the company is not necessarily something that they're going to find positive. What's a provisional? It's simpler, it's cheaper, but it does expire within 12 months. Provisional applications are not actually examined. And so I get this all the time by clients. Well, how did the provisional application go? Should we file a full application or not? What did the patent office say? The patent office said, here's your serial number. That's what they said. Like, you got a provisional. That's it. They recognized it. Here's your official filing receipt. That's pretty much all that the patent office will actually even say. What are the advantages of a provisional application? It establishes an early date. This is going to protect against loss of patent rights, especially foreign patent rights. You don't need claims, and because you don't need claims, it makes it a lot easier and faster to write, and it's cheaper. As I mentioned before, we charge about a third of what we charge for a full patent application for provisionals. We charge $15 for a full, but we only charge $5 for a provisional application. Delays this whole process. And so, especially when you're in this particular area where you have a good idea, but you know that you're actually going to make it and test it later on, this is a perfect example of why you want to delay that 12 months. It's possible that the assignment that you turned in last night, you will have figured out that good ideas aren't typically patentable. Or if it was your own good idea, you're going to probably argue that that was totally patentable. But if it was someone else's good idea, you're probably arguing that, hey, look, there's a whole bunch of other people who have thought about something similar. I actually don't believe that good ideas are patentable. Because there's too many people thinking too many things and posting too many things and filing too many patent applications. And so it's very difficult just to get good ideas. But you want this early date. You want the patent office to recognize this date right here. Because it's possible that some of these claims that you file in this later patent application, you're going to need to have that date because some of the prior art that gets filed after it. And so it would be great to get that date. But what you really want, this is going to add the strength to your patent application. Now you've worked on this. You're smart, you're talented, you're funded, you're working on it long enough. You're going to come up with something that's patentable. Just about guarantee it. Because now you've gone much further into the woods than anyone else has. And the deeper and deeper you go, the more and more you're going to come up with patentable subject matter. Or patentable inventions. My own analysis of the work that we've done, the first couple patent applications that we file for clients typically has somewhere about a 60-70% allowance rate. And that allowance rate nearly jumps to 100%. 95%, 100% after the first couple patent applications have been filed. That makes sense. You now have a bigger team. You're the only ones that are doing this. You're well funded. You're focused on this. Of course, you're going to come up with every single idea, the improvements on some other core technology are going to be patentable. It's the first couple that you want, and so that's why you take that risk. All right, it's only a 60% chance, but that's a chance that we're going to take because if we get that, that's going to be incredibly important.
You don't have to, but does it also mean you shouldn't put anything in there?
I don't like it. And if a client gives me a provisional application for me to file on their behalf, I'll typically strip them out. There's one country, at least when I did the analysis a few years ago, I think it was Thailand, that wouldn't recognize a provisional as a provisional unless it had claims. And so what we typically do is say, we claim the inventions described in this document. And to us, that's not really a claim that we have to put in any effort towards, but maybe that would work as a claim if some other country requires a claim. None of the countries that we typically would go into would object to the claims, that kind of omnibus claim that you would write. A question over here? Yeah.
I was kind of curious about how provisional patents, the secrecy of them, so like how that kind of works. So when you file a provisional patent, it's like stays secret until, unless you want it to be public. Like, so if you kept it secret, then 2 years later you actually file a real patent, you don't get that priority date. But then if somebody tried to say that, like, appealed your patent and said, no, we actually came up with that idea and published in between the provisional patent and your real patent, could you then say, oh, I want the provisional patent to be made known so that at least I won't be blocked from making that, or, you know?
So you might use that as some kind of date. Hey, your lab notebook burned in a fire, and that's the best evidence that you have is the official filing receipt and that patent. I've never used a provisional as evidence of an invention. I've never had that weird case where we didn't file on time, but then we later needed to do that. Those are kind of two weird edge cases stacked on top of each other. But that's something where you could use that document, but you wouldn't say, let's go make that publicly available. I would just say, on this date, we had this particular document. Clearly, we gave it to you and gave us a receipt on it, and here's what was in it. If you claim priority to a document, or provisional, which is to say, within 12 months of that provisional application, you filed a full patent application to say, hey, I want this provisional to be recognized as a priority document. If you do that, when that full patent application publishes, that provisional will be publicly available. And so you'll be able to dig through the file history. Remember, we did that in one of the earlier classes of looking at all the office actions. In that same exact setup, you'd be able to dig through and actually find the provisional. But if you don't ever do that, if you don't claim priority to a provisional, then that particular provisional is secret, and you can't find it. No one else can index it or look at and even know it exists. So it's not publicly available unless it's actually used, successfully used.
Several patents that refer to the same provisional?
Yeah. And so this is kind of a one-to-many. And so I think this is an important concept because I think most people think of this as a one-to-one. And so I've already introduced the concept that you could file again in a couple of months if you have an idea, an improvement on your invention. To essentially take that same provisional, add a paragraph or two, and then just refile it, or file again. I don't want to use the word refile it. File it again. And then you could merge those two later on, or you could drop that first one, and it will never actually show up. But you could take that provisional, we were talking about this today, with one of our clients, that there was a provisional application that had 1.5 ideas. We couldn't figure out whether or not we were going to split that or not. So you might have 3 provisional applications and 3 full patent applications, and 2 of these go into 1, and this one goes into 2. So there's definitely no 1-to-1 ratio on provisionals. You're effectively just saying, on this date, I had this piece of information.
How long can you feasibly go on filing like provisionals without actually filing, just because you won the patent pending sort of label? Because I attended a talk once and there was this Stanford guy who says he's created like these corporate structures, MLPs, that take advantage of, have these like tax advantages. And he was saying that the way he set it up, he's able to like make a lot more money, but then he doesn't want anybody to actually know how it's set up. So he keeps refiling just so it's secret, and it's like his defense, I guess, strategy. So how long can you keep this going? I don't know if that was true or not. But.
Yeah, there's no, from what I'm gathering of what the story that you're telling, there's no reason that to stop, but once there is a public use or public disclosure, then you can't go back more than a year, right? So you could keep on filing provisional applications on the anniversary every single year and let the other one die. But you can't go more than 1 year back. And last year, one of my students said, well, what if you just take the same patent application and file it provisional application, file it every single day? It's only $125. And then you go back, when you're ready to file a full patent application, you just go back 1 year and you take that one. Makes a lot of sense, actually. I don't know about filing every single day, but maybe it makes sense to file every week or every month. We don't typically do that, but there are times, because we typically think that, like, all right, well, in 12 months we'll be there. And if we're not there, we don't find out until pretty late. And then when we find out pretty late, then it's like, all right, well, do you want us to just refile that provisional? I don't like doing that because we've given up all of this all of this great time. We had this 9-month advantage, and now we just squandered it. So that's not ideal to be doing that. But it's totally doable.
Good question.
Yeah.
Given how easy it is to file a provisional, has there been any effort made to automate the process? Where, for example, if you wanted to file it once a week, just have your employees update their ideas for the day into some kind of a template and have them, every, once a week file a provisional with whatever it is, cut and paste it in.
I think we should file a provisional application on that as a business method.
It can't be a good idea because somebody would have to have done it already.
Use my own words against me. The provisional application doesn't count towards the 20-year term, and so this is great from a pharmaceutical standpoint, and when that last year is actually incredibly valuable. But it does, from a software standpoint, it does delay the process. You actually want an issued patent now. You actually want to issue a patent like 6 months ago. Like, you don't want to delay this whole process, and you don't want that extra year 20 years from now, especially from a startup standpoint. What you really want is it now. And so sometimes we'll file a provisional application and actually file that full patent application early. Just because the earlier we file it, the earlier we'll get an office action, the earlier we'll get this whole thing issued. And waiting that 12 months is effectively just delaying the whole process 12 months. It does allow the use of a patent pending phrase. And for whatever that's worth, that's great. It only costs $125 to do that. These are the requirements of a provisional application. That you actually have some written description of the invention. In nearly all cases, you have to have drawings. Drawings are typically at the end. In academic papers, they're usually embedded in the middle. But it's typically sorted out. Here is the text, and here are the drawings. You have to pay a fee. You have to give them some information about you. What's your name, your home address, your citizenship. And then you need to submit it or mail it. If you mail it, again, use express mail. And that's it. It's relatively simple. Let's dive into the written description. We'll get to that one, sorry. So what should the written description include? These are all the sections that you would typically find in a full patent. The title, the technical field, background, summary, brief description of the drawings, detailed description of the embodiments of the invention, claims, and the abstract. The ones that I've crossed out in red are the ones that you don't actually need for a provisional application. And in fact, I would strongly urge you not to work on a background section, and not to work on a summary section, and not to work on an abstract, and not to work on claims. The most important thing of a provisional application is that it supports the claims of a later filed full patent application. And to support the claims, you need to have a written description of that invention. And the more, if you have a certain period of time to do this particular document, every single minute that you would have otherwise wasted trying to guess at claims, but that you put into brainstorming better variations and putting more information into the written description of the invention will serve you very well. I can't tell you how many times our clients have said, we've changed and evolved so much from that provisional application. There's no way that that's going to work. Well, just tell us where you went and tell us what you're doing now. Well, we're not doing this anymore. We've now moved it to the cloud, and we're not actually doing this desktop application anymore. It's all on the phone, and we're doing all of these things right here. Well, let's see what we actually wrote. And we go back to the provisional application, and of course we added all of those options in there and all those different variations in there. And so it supports it. And so this thing went from potentially useless to actually incredibly useful again. The title you should spend about a minute and a half on. If you just want to say a system or a method, that's totally fine. This is not going to have any legal significance whatsoever, and to spend any more than about a minute and a half doesn't make any sense.
People try to kind of hide what's inside by having a very vague title.
So provisional applications are not examined.
No, but yeah, for the patent.
For the full patent application, I typically use the preamble of my claim. And so when you're doing a text search, you're not just limiting it to titles. Titles are pretty useless. And so there is a strategy on let's try to make it so that very difficult for other people to find our particular patent application by using all these obscure words instead of these regularly used words. I don't prescribe to that. I just think that makes things very confusing and vague, and I'd much rather have something crystal clear as to what kind of protection we have. But there is definitely a strategy of patent attorneys trying to be too clever. So the title, I'd spent a minute and a half on that. The description of the drawings, just tell them what you drew. It's not too hard. Here's a flow chart. This is a left view. This is a perspective view. You need it in there because later on that could actually help quite a bit. That's actually well spent time, but don't spend much more than a few minutes on that. So then where are you spending all of your time? If this project's going to take 20 hours to complete, I want you to spend 19 hours and 55 minutes on the written description part. That's actually where you're going to benefit the most from. We did an invention capture. I did a bubble map or mind map on the board last lecture. And that was about trying to identify these different steps or different elements. When we went back through, just to refresh your memory, the seal, the valve, the cantilever, the actuator, the handle, the container. It was the RFID parking structure. And so it was the method of actually providing it and tracking it and getting it back and reusing it. This is what I mean by 3 to 5 essential elements. Whether it's a method, and these are steps, or whether it's a system or a device, and these are components or parts. Talk about those. Talk about what their function is individually. Talk about how they're related to each other. Talk about giving more description and details about those. Well, this is how it would look. This is one way of doing it. This is one option or one variation. Here's another variation. Of course, it could be this other variation over here. Go back down to the next element and talk about that one. This is what it does. This is how it's related to the other elements. And if I were to provide some more details, I would say this. But it could also be this thing over here. It could be made out of aluminum or magnesium, or any other particular type of metal that's strong and relatively lightweight. A lot of times people like to use just a lot of fancy legal words. I wouldn't recommend it. I want this thing to actually read like a white paper. And oftentimes our clients say, well, the provisional application is going to be really easy when I write the white paper. And I often turn around and say, your white paper is going to be really easy when I write your provisional. And oftentimes that's actually the case, that they take the provisional that we write and say, this is the best description that we have of our technology. I want to use this as a white paper. And these two things actually kind of look a lot alike. You're teaching someone how to make and use your invention. You're teaching someone this is what we make it out of. These are the parts. This is how it works. This is what this function has. And yet early on, you don't know exactly what you're going to use, and so you give a bunch of options. Or if you have chosen the identical, or the exact one that you're moving forward, go back in time and say, these were some of the other ones that we considered. And put those in your provisional application too. That's actually what you get your breadth from. And so you want to have a broad coverage. You want to be able to go back and say, all right, I didn't just disclose something very narrow. And the best way to do that is to be able to disclose something in all of its details, and then give some other variation on that, and another variation on that. And now you've actually grabbed some very broad area by being able to specifically describe a bunch of very 3 or 4 variations with a lot of details. You want to be broad, but you have to be specific. If you're not specific, you're not going to get the date. So how are you broad and specific at the same time? You're broad and specific at the same time by being specific in a bunch of different areas. I'm talking about a bunch of different variations, and that's what gives you your breadth. And that right there is the whole trick to a provisional. Most of the time when inventors do write their own provisionals, they know that they want to be broad, but they end up being vague. And if you're vague, you don't get your date. The way to be broad when you have to be specific is to be very specific in a bunch of different variations.
Very narrow variations. If you need to do litigation to defend your potential subject matter, can you combine different aspects of all these narrow variations?
So in reality, what makes the most amount of sense, and if I could kind of go back to the concept of our bubble map, it's not necessarily the 3 very specific variations, but rather, all right, so here's your invention at the high level. And each one of these has a bunch of different variations. And so effectively, what you're trying to cover is whatever, for, I don't know how many, there's a lot, 256 variations that I just put up here, or something bigger than that. With all of those variations. And so on a high level, the invention is, these 5 pieces together. And then you spend a little bit of time with each of those individual pieces describing all the different ways of doing that. You could use any combination. And so you have an enormous amount of breadth here, but you're very specific. And another way to kind of add some additional breadth is to be able to have some optional elements. Or some of these, so to be able to say, all right, these are the essential elements. There's a bunch of other ones that could go along with this as well. And each of these might have a bunch of variations on it. And this is why this thing kind of looks like a term paper or a white paper or something. It's a very scientific paper. It's not a legal paper. This is what goes back to one of the very first lectures. We talk about there's 2 radically different documents in a patent application. There's a technical document, and then there's a legal document. We're not creating the legal document here. We could do that in the next class, ME 238, the law school class. That's not what we're doing here. We're doing the technical document. You guys are all clearly able to do that. Yeah.
So this came up in my, patent search I turned in last night. But I'm sorry if this question is phrased really poorly because I've been thinking about how to phrase it since a couple days ago. But the particular field that I'm working in often involves design kind of by trial and error, where to get an intended effect, you design the product until it gets that intended effect. But I realize that in the patenting, you're actually patenting the device, not the effect. I mean, unless you're, patenting the effect. But for the device itself, how do you, even in a provisional patent, kind of say, can you say this device is going to be designed to do this without specifying exactly how? Because it's not exactly clear. You know the steps to get from here to here, but it's not clear exactly how to go from here to here, for instance.
You may run into some utility problems. You may run into a bunch of other, hey, you didn't actually provide enough written description here to show that you had the invention. And so those may be some problems. But a lot of times, there's only a finite number of different options that you may have. If this is a medical device, and it's all right, well, we're either cutting, or we're suturing, or we're inserting, or we're removing. And there's only so many different things that we can do with the body. And so, all right, what are the different tools that can do those things? And what are the different tools and variations on that? And so there's almost like this huge template to be able to say, all right, throw all of these paragraphs down. We do have a couple templates on the software side that, all right, so to implement this particular code, we could either do this here on the server, we could do this here on the client, the phone, we could have it distributed. And so we have a bunch of different kind of stock paragraphs just on the software side. We could do this as in either pharmaceutical or med device as well. Does that answer your question?
Issue, and I'm not sure how exactly this fits in with the provisional application stuff, so I'm sorry for being a little off topic. But the particular issue in my case is that there's a similar patent. There's prior art for something where it's basically, they're both refractive lenses, but they're designed to do very different things. So the outcome is different. The design is also different. It's necessarily different. Otherwise, they don't, they have different effects. If they're the same, they have the same effects. But it's not clear from the patent that I'm referencing. That patent doesn't really specify so much, what the refractive lens itself is doing. So it's unclear to me how to differentiate those two and to say, this is
that's
physically
probably where your
different.
invention is going to lie. And so we don't have the invention yet. That's probably the short answer to that. I'm happy to continue that offline. Any other questions on this stuff so far? Yeah.
Looking at these kind of subgroups out here on the periphery here of all these little variations. I guess a couple of patents I've worked with were basically those external rings are basically the same thing. It's saying it's blue, it has this invention with a hole, this invention with fur on it, and this invention with bubbles coming out of it, and then you just say those on all of your other 5 parts, and so you end up cutting and pasting about 30 different times. I mean, is that something typical you do in a patent, or can you
So
just
it
say?
depends. If this is, I don't typically like to just cut and paste. I happen to bill a flat rate, and so maybe it makes more sense or less sense. I don't know how that would work. But what I'm trying to do there is be able to expand a bunch, in variations, and those variations I don't necessarily see that as being something that could be just cut and pasted. If these variations right here are identical to these, then I question whether or not these two things are actually different at all.
Well, for example, I think it was a catheter, where you have every catheter can be either 50 centimeters long, 100 centimeters long, or 200 centimeters long. It can be out of this diameter material, this diameter material. So you have all those different variations on some core technology, which is maybe you have a different deflection mechanism in the handle. And so you say, well, it's this catheter with this deflection mechanism in the handle, but it's 50 centimeters long, but it's 80 centimeters long. And then you say, I have a slightly different handle, and now it's 50 centimeters long, it's 100 centimeters long. So
Let me try to approach that particular question. When I threw these things out here, size, this is hopefully something that is actually patentable. And so things like size and diameter and materials aren't typically patentable. That those aren't typically adding anything that's going to make this thing, all right, well, wow, we saw it in this particular size before, and now we're going to change the size 20%, and that's going to be patentable. That's typically not the case. And so when I talk about being more specific, it's more about the functionality, and it's more about some of the things that are actually part of the inventive process that we're now adding. This second ring you don't typically get until you've actually made this thing and you start figuring out some of the stuff that worked and didn't work. And this wasn't just throwing out a bunch of different lengths and diameters and materials. That this is more of we could actually do it where it's inserted from this angle, or we could do it where this is we split up the surgery, in these particular ways, or that this used to be made from 2 blades, but there's also a 1 blade option here as well. So I'm talking much more radical variations than these seemingly meaningless ones from a patentability standpoint. And if they're much more of bigger variations, that's going to add to patentability, and I don't imagine that that's going to be something that you could cut and paste around all of the different elements.
I heard about something about putting a picket around your yard, or finding the white space, finding the open spot. I was wondering how much is that, filling out all those different possible options, making it that broad as possible.
That stuff right there, I don't think is actually adding much to the patent. And being able to go back through and figuring out what this one is makes more sense to me. What you're describing actually seems much more like this.
You could write an algorithm to generate, 80% of content in some of these patents.
And I'm not worried about like the 7th ring. I'm worried about like the 2nd one. Okay, drawings. You need them. Actually, the more the merrier. We could always choose later on which ones we're going to move forward with the full patent application. And they don't actually have to be nice looking. Just do a hand sketch. They don't actually have to have reference numbers, but make it so it's relatively clear what's going on. You could actually just label it with the actual words that you're using in the provisional. You don't have to use reference numbers. Reference numbers actually take a decent amount of time. So you could label it with the actual words. It needs to be clear. It needs to describe. It needs to teach. But it doesn't need to be fancy. And so you could waste a lot of time making really fancy drawings, where that time could be way better spent making more drawings. Ideally, we have the same or very, very similar drawing, very similar subject matter from a full patent application to the provisional. And so if you have more drawings to choose from, then the chances that one of those drawings is identical is fantastic. That's what we want. I want to be able to say all these drawings were in the provisional. How much could it have changed, Judge? I want to be able to say that. And so having more drawings is actually more important. All of you have different drawing abilities. That's fine. All I'm looking for is not nice drawings, not great drawings, but just something that gets the point across. If you want to take a photo of your drawing and then insert that into your document, that's fine. Doesn't have to be fancy.
Fancy drawings, because you always see handwritten drawings, but if it's a white paper and it comes out of a technical document, sometimes they're very.
I meant easy drawings. They don't have to be hand drawn. Okay. You don't have to go back and reduce the quality of them. Whatever you have.
So we can also put figures that could be figures on academic papers that support the knowledge.
Figures don't typically help, but yes, you could definitely use that.
What about photos of prototypes?
That works too. We could turn those photos into drawings that actually work for a full patent application later on. Take a bunch of photos, show a bunch of different angles. Yeah.
How do you show something that's like a software thing? Do you show the output of it? Because it's hard to show the method without just
There's 2 different types of drawings that I like to use for software. One is just a flowchart. And that flow chart is, all right, so there's a bunch of things going on over here, and then this is kind of inputting that way, and then this gets split, and then this information goes over there, and then this moved over here, and we've all seen this before. This is a flow chart. That's a really bad one. And then the other one that is more used in kind of communications is that this signal goes over here, we take it back, and then we go over here, and we do something with it, and then this goes over here, and then back to here, and then that, and then, so these are different players. This is your phone, and this is some server or database, and this is some cloud, and this is some other person's phone, or whatever that is. And these are just kind of communication signals going back and forth. The great thing about this is that it kind of shows some steps. We could now say that, all right, this is the first step of transmitting, and this is a step of receiving, and this is the step of going out here, and then it's doing some processing and things like that. And so this thing kind of looks a lot more like steps to me than this does. But either one of these will work just fine in the software space. Yeah. Wireframes would be great, but it does often show more design than steps. And so if you're going to have wireframes, you're going to also need to have some kind of flow chart that's going to look more like that. I'm going to talk about one more thing right here, and then I'll let you guys go. Who should be listed as an inventor? This is a really important topic, but inventorship is actually based on the claims of the full patent application. And I just told you that we don't have any claims in this provisional. And even if we did have claims, it's the claims of the full patent application, not the claims of the provisional. And so what we're trying to do is our best guess as to what the inventors who made a contribution to what we think we're going to claim later on. This isn't necessarily all 8 people because there are 8 people in the brainstorming session, although that's sometimes easier to do. We're trying to get at who actually made a contribution. There needs to be at least one shared person between the provisional and the full application. You can't have a completely different inventorship that doesn't have any union between those two. And for that reason, you might want to be slightly more inclusive. What I typically see for provisionals is somewhere on the order of maybe 4 to 6 inventors, and then for a full patent application, maybe it's more like 2 to 4. So you'll kind of see a little bit of shrinking. And I've already talked a little bit about just kind of the warning that this thing does expire. There is no late. You can't get an extension. So the next assignment, that's why it's due at 9 o'clock Pacific time. That's when you need to file provisionals, by 9 o'clock Pacific time. I'll see you guys next week.
For more, please visit us at stanford.edu.